everyone, it's Karen Roberts from the Emerald Financial Group. Welcome to Take a Minute Thursday. Hope y'all are doing great. Hope you're enjoying these educational videos that we are doing for you every Thursday. If you happen to miss any videos, please visit my website, emerald-financialgroup.com. Under the video section are all of our Take a Minute Thursday videos. And in the meantime, we have a guest today. Yay! We have Nicole Loughlin here, who is an estate planning attorney, and she's going to talk about your estate planning documents and what the heck does that really mean. Take it away, Nicole.
Thanks, Karen. Yes, I'm Nicole Loughlin, Loughlin Law, PA. I am an estate planning and probate attorney in Boca Raton, and right now during the COVID pandemic, we are offering our services 100% virtually, and we'll continue to do that post-COVID also, hopefully soon. So what is in a comprehensive estate plan? Well, we routinely draft estate plans that include a last will and testament, a durable power of attorney, a designation of healthcare surrogate, and a living will. And I'll talk about each one of those. We also occasionally will add into our packages HIPAA authorization documents to allow people to view your medical records, which can be important if you have young adults who are your children, and you may want to have access to their medical records. And we also include declaration of pre-need guardians. So I'll start first with what I believe to be the most important document, as it's to be used during life, is the durable power of attorney. The durable power of attorney is a document that allows you to appoint an attorney in fact who will be able to step into your shoes and make legal and financial decisions on your behalf. So that means this person will be able to access your bank accounts, write checks, pay your mortgage, your rent, sell real property, basically anything that you authorize them to do in your durable power of attorney. The durable power of attorney takes effect immediately. And so if you're one of those people who got on a cruise ship in January to travel around the world, and 2 months in, you find yourself in the midst of a global pandemic, but you were supposed to sell your house in April, well, your attorney in fact can go get your durable power of attorney, sign all those closing documents, and finalize your sale. So this document can be used whether you have capacity or whether you're temporarily or permanently incapacitated. Along the same lines, we have a designation of healthcare surrogate, which allows your healthcare surrogate to step into your shoes and make healthcare decisions on your behalf, which is critical if you're unable to make those decisions for yourself, that you've appointed somebody who has an understanding as to what your wishes would be. And to help them with that, we have the living will, which is basically your instructions to your healthcare surrogate. If you're in an end-stage terminal condition or in a persistent vegetative state, your living will direct your healthcare surrogate to make a decision based on what you want for the end of your life, whether you want extraordinary measures to be taken to keep you alive, and whether or not you're going to grant your healthcare surrogate permission to quote unquote pull the plug. Now, people right now are concerned with their healthcare or with their living wills because they may want extraordinary measures to be taken to save their life at this point, which could include a ventilator. So those are decisions that people are thinking about right now. What a living will is not, it is not a do not resuscitate. A do not resuscitate means don't save me. That's not what a living will is. A living will comes into play once really there's no hope. You are at the end of your life. If you're in a car accident and there's a chance that you can be saved, just because you have a living will does not mean that the medical staff is not going to take measures to save your life. So there's a difference there. And finally, the last document is the one that everybody is familiar with, and that is the last will and testament. And this document becomes effective upon your death. So upon your death, this is the document that will be deposited with the court. It's the document where you nominate a personal representative who is the person who's going to make decisions on behalf of your estate. That means they're going to petition the court to open the estate. They're going to identify all of the assets of the estate. They're going to identify and put on notice all the creditors of the estate, and they're going to make distributions to the beneficiaries. Also, in your will, you're going to nominate a guardian for your minor children. So if you have minor children, you must have a will. You must make that designation. And oftentimes, Karen and I have talked about it. If you have somebody who you would not want to serve as the guardian of your children, you must have a will and a nomination of guardian.
Right, because otherwise the court, correct me if I'm wrong, but the court will decide who is the guardian, and normally they're going to decide by who the biggest amount is, and typically that biggest amount isn't who you want raising your children.
That's right. That's right. And that brings me to another point that we've talked about, Karen, and that's that you don't have to nominate the same person for every position. Many times people have a family or circumstances that would allow them to say, my sister is perfect for every single designation. But other times, you know, life is more complicated than that. And you might have somebody who is great with money, who would make a great attorney in fact under the power of attorney. And you might have somebody who's very compassionate and would make healthcare decisions based on your wishes. So you have to make decisions based on who the best person is for that role.
Right, and for those of you that don't know, I have 4 kids, and there is an age gap between the older 2 and the younger 2. So we updated our guardian probably every few years, depending upon really who would be best for the kids at that stage. Now, fortunately, my youngest is 20, so we don't have to worry about it anymore. But I wanted to make sure that the kids and the guardians could all intermingle and take care of themselves. Hugely important. Please don't put it off.
Absolutely.
So perfect. Thanks so much, Nicole. I hope everyone appreciated just kind of an outline of what estate docs look like. Next week, we're going to talk about, do I need a trust or is a simple will enough? And what is the difference? So thanks everyone for participating. Again, Karen Roberts from the Emerald Financial Group and Nicole Loughlin from Loughlin Law, PA. We are available to help you with anything that you might need. Take care. Have a great Thursday. See you next week.
Thank you.